Juan here, president of Sage Real Estate. I'm sitting down with Christine Brown. She's an attorney, estate planning and elder law. She's going to be helping us answer questions specifically to apartment ownership and the importance of proper estate planning. Christine, explain to us what estate planning is.
Well, estate planning is really a plan that contains a number of documents that you should have in place. In the event that you become incapacitated, you want somebody to be able to manage your finances, your healthcare decisions, as well as assist you with the handling or the probating of your estate after you pass away, to make sure that the people that you want to inherit your estates are named in your estate planning documents, as well as perhaps the conditions upon which you want your estate to be distributed.
Great, thank you. Christine, a lot of our clients, they're longtime apartment owners. They've been managing their units, and the reason they bought 30 years ago was to someday retire, right? What advice do we have for those apartment owners when it comes to proper estate planning?
So some proper estate planning documents that your client should probably have in place is actually, doesn't really matter whether they're apartment building owners or homeowners or renters or tenants. There are probably 3 or 4 documents that you should have, one being an advanced healthcare directive, and that's kind of on everyone's mind at the moment because of COVID, right? We're hearing about people being on ventilators, having serious medical issues, and your clients might be concerned about, like, who's gonna make my medical decisions for me if I'm not able to do that. And that's what the Advanced Healthcare Directive does. They should also have a durable power of attorney for finances. So if for your client, if they own an apartment building and they're perhaps in the hospital and incapacitated, if they don't have a durable power of attorney in place, then no one can collect the rents on the apartment, or pay the property taxes, or pay the property management company, or any other expenses that arise with the apartment building. They should also definitely have a will, which is a document that states how you want your estate to be distributed when you pass away, as well as who do you want in charge of making sure that your taxes are paid and your bills are paid after you've passed. If you have minor children or even disabled children, it's really a good idea to have a nomination of a guardian or a conservator so that someone can step in and help take care of your children if you're not able to do that. And then the last document is usually most relevant to people that own real estate, because my clients tend to not want to go through the probate process, and a trust allows you to transfer title upon your death without going through the probate process here in the local Superior Court. And the other benefit that a lot of people don't know about is that the trust is effective the moment you sign it. So if you become incapacitated, you name someone, a trustee, to step in and help you manage all of the assets that are in the name of your trust.
Okay, wonderful, thank you. Christine, what are some of the most common mistakes that you see apartment owners make when it comes to estate planning, or lack thereof?
Probably the number one is they either don't have any estate planning in place, which will result in conservatorships, probates, all of which are very expensive and subject to court supervision. So we're talking about a lot of time, a lot of lawyers involved, or not having updated your estate plan. I think a lot of people think that if they do their trust, they just put it in the binder, stick it in the closet, and it's all done. Well, sometimes that works out that way, but it's really a good idea to look at your estate planning documents and see who you've named as your executor. So you might have named your brother, and he passed away 5 years ago. So now you have him as your executor or your trustee, but if he's deceased, he can't act in that capacity, and it's almost like not having an estate plan in place. The other thing is, please don't panic. I see people who are going into the hospital, or maybe they've been diagnosed with a terminal illness, and they'll add their children to the title because they think, oh, I'm going to avoid probate. Well, you are going to avoid probate, but you've now caused potential legal problems. Let's say your child has a judgment against them. Well, the creditor's going to go after the real property and put a lien on it, which you don't want, obviously. And the other issue is there's a capital gains tax issue. If you let your children inherit the property with either a will or a trust, you avoid a capital gains issue potentially. Or if your child's on title and you want to try and sell your real estate, well, guess what? Your child has to consent to the sale of the property, and if he doesn't, you can't sell it, and then you end up going to court and suing your child, which is not a position most parents want to go and get themselves into.
No, definitely not.
Yeah. I think those are probably the top two that I see.
Okay, perfect. Christine, thank you for being here. So a few takeaways. One, please make sure that you have a trust, okay? So that should something happen to you, there's something in place to protect the property that you know and love. And also do everything you can to avoid probate. You've worked hard. We don't want to lose a lot of those funds to the probate process. And with that being said, if you haven't gotten started with estate planning, if you need to open up that estate planning again, because it's been a few years, I ask that you please reach out to Christine Brown. We're going to have her information down below, and we thank you for tuning in.